Welcome to ThePrint. A few weeks ago, a 27-week pregnant woman approached the Supreme Court demanding to get an abortion. While considering the case, the Supreme Court swung between the rights of the woman and the rights of the unborn child, and this case seems to have brought a new perspective to the abortion debate in India. So, of course, in today's episode of Laws of the Land, we bring to you a discussion on the abortion laws of India, the Medical Termination of Pregnancy Act 1971. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra, Sinha, and we have with us Supreme Court lawyer Pallavi Pratap, who you've seen on this show before. Thank you so much for joining us, Pallavi.
Thank you so much, Apoorva and Bhadra, for having me here. And a very interesting topic that we are discussing this morning.
Yes. Sure. And we would definitely like to touch upon the judgment or the order which Apoorva has referred to. But, and of course, the trajectory of the MTP Act. But before we proceed with that, we would like you to reflect upon the objective of the Act and the basic provisions, as in why this Act was introduced, what is it meant for, what kind of relief, and what kind of rights has it actually given to a pregnant woman.
So I think, interestingly, India was always very forward-looking, if you look at it. I mean, still, it took a long time for America to reach this stage where Roe versus Wade happens, and then, abortion sort of gets legalized, and then the reverse happens, which we witnessed last year. Now, here in India, at least, we noticed that way back in 1971, we were talking about termination of pregnancy, which is primarily that every woman has a right over their body. However, if you look at the statute and the wordings of it, it was primarily for married women. Yeah. So single women were not really brought under the purview. However, even a married woman was given a right that to certain number of weeks, if there is a problem that they face in certain circumstances, they can go and terminate a pregnancy. Now, this was 1971.
Yeah.
Then we see that in 2021, primarily actually in 2020, where we see that, a bill is brought and certain changes are brought about.
Right.
So, whereas in 1971, we were talking about something which was just 20 weeks, now we were talking about a fetus which was about 24 weeks. And here, the purview was then extended to all women. So, it was not necessary that a married woman was looking at termination with the husband. The terms were changed to any woman and a partner. So what we see is that, the entire purview was changed. A lot of women who were actually, I don't know, Bhadra, if you remember it or not, but in the 90s, in the 80s, there used to be these mom and pop shops of abortion. And if a woman who was not married and she wanted to seek an abortion, it was an entire gang which was operating. Yeah. And these women did not have access to safe abortion.
Right. Yeah.
So now the safety part actually came into fore, and women had that choice, which, a lot of times we have that pro-choice and pro-life debate, which I'm sure we will be touching upon later. But women as such had a choice and a right over their own body, whether or not they wanted to have a child, at what stage in their life they wanted to have a child. I think that sort of vision was brought about. And the statute became a law only in 2021. However, these discussions were going on from before. But those changes which were there, those were reflective of how progressive the country was moving. And even in this judgment, if you see, that we will be touching upon, right, I think at some stage you might feel that it is not as progressive. But I think it is just how one is looking at it. So I think we'll debate about it.
So the changes which we saw in 2020, first of course was the gestation period was extended from 20 weeks to 24 weeks. And second change that was brought about, which you say was a very significant change, was that in the category of women, it went beyond married women, right?
Correct.
Pallavi, but there are certain circumstances only, as per the law, under which a woman can get her pregnancy terminated. Can you just talk about those circumstances? And was there a change in these circumstances from 1970 to 2020?
Yes, I think, we noticed that, with the evolution, crime against women was always there. It's just that, the recognition was not always there, because a lot of things were accepted that, okay, this was a general tendency. However, what we notice here is that now with Section 3, when you look at the explanation actually covers different victims. So it could be a rape victim, it could be a minor, it could be an incest, it could be differently abled woman. So all of these women have now also been brought into, the entire explanation of Section 3, and it provides that up until the 24th week, a woman who comes under these categories can avail for medical termination of pregnancy. Earlier, it was only till 20th week. And there were these categorizations which were made, that from 0 to 12 week, it was only one registered medical practitioner whose opinion was required when it comes to termination. But now what they've done is that 0 to 20 weeks, you will have an opinion which will then comprise of 2 RMPs now. And also, interestingly, what they've brought about is that there is a medical board. And I think we've seen that evolution also, Bhadra, because I remember one of the first cases that I did sometime in 2017, there was a young rape victim. And we saw that there was and she came from Patna, if I'm not mistaken, little girl of about 15-16 years, and she was 24 weeks pregnant. So they had constituted a medical board, and this definition has now come into the statute, where you have one gynecologist, one pediatrician, one radiologist or sonologist, and any other one person who is nominated by the state or the union territory. So this, I think, has been a way forward to ensure that nothing is going against the statute. But what we are also seeing is that in the judgment that came, there is an entire discussion on fetus viability, which is nowhere defined in the statute, however.
Right.
So I think this is a new thing that we have noticed, and which maybe later on would require desired amendments in light of it.
Pallavi, so we've seen, of course, we have this law which talks about registered medical practitioners coming in, a medical board. But I feel like there's a bit of confusion on when a woman has to or needs to go to the court for this. How did that evolve? How did that come into picture?
So earlier, what we were noticing was that Article 32 was exercised by women that we just discussed in the explanation. But now this peculiar case was about a woman who already had 2 children. She had just given birth to her second child, and she is not coming from a very good economic background. And she says that my child is only about a year old. I'm already going through postpartum depression. The woman was not capable of having another child so quickly when she just had another child. Now the trouble was that she only realizes it at the 24th week, which is, as per the statute, that time period has gone away. And she doesn't fall in that explanation. So therefore, she cannot avail any of those, rights that are given. So what she does is she approaches Supreme Court under Article 32, saying that because there will be a mental impact on me, since I'm already going through postpartum depression, if I conceive this child, and therefore I should be given the liberty. The first round of in the first round of litigation, we see that Honorable Justice Hema Kohli and Justice Nagaratna say that yes, the termination should go on, and they agree with the reasoning also. However, then subsequent events take place, and therefore it says therefore a judgment comes where they say that it is not the right way of moving forward, and that there is something called as fetus viability. My little 2 bits on this is that the entire judgment is based on the fact that the fetus has a heartbeat. And if we look at it, from 7th week onwards, the fetus actually has a heartbeat. But what really happens is that when you are aborting a child, or when you are medically terminating a child, there are 2 ways of doing it. One is, of course, you have to stop the heartbeat if it has reached a certain week. And in this case, about 24 weeks, the child's heartbeat was very good. He was in a good shape. And it was not that there was some mental problem that could have emerged. So the interesting part was that the judges say that because there was a fetus viability, therefore stopping the heartbeat at this stage is not the right way forward, because one, the statute prohibits you, and two, we don't want to exercise that under Article 142.
Yeah, but Pallavi, just wanted to talk about, this is not the first time I think a case of this nature has really come to the Supreme Court. Maybe for the first time, the court has touched upon the fetus viability part. But in the past, we have seen courts permitting women to terminate an abortion. Can you explain on what grounds, has the Supreme Court permitted them? In the sense, was it because the girl or the woman was, there was some sort of risk to her life, or there was a risk to the fetus? In the sense that there exceptions have been made.
Absolutely.
On what grounds?
There have been quite a few actually. The one that comes to my mind is, of course, the fact that it could have been hazardous to the life of the mother. Two, I remember one of the cases which I'm not very clear when it was, but sometimes what happens is that the situation of a woman changes. So for instance, I may have conceived a child, I'm married still, but maybe by the time I reach my 24th week, I may be divorced, or I may have become a widow, and I don't want to carry on with that pregnancy. So those specific exceptions have been taken note by the court. Or it could be because of any other reason. So it could be that sometimes we've seen it on streets a lot of times, that you would see some mentally challenged woman who is pregnant. So then in those cases also NGOs have filed and got that kind of a medical termination done. So these are specific situations where the court has intervened. However, it is not something that they want to make it a rule of thumb, because there is no statute or there is no section, there is no act which tells them that this is a right which is given to you beyond 24 weeks.
Yeah.
It's only under special circumstances that they can do that.
So are you trying to say that till 24 weeks, a woman has absolute right to get her pregnancy terminated?
It is not necessarily like that. It is up to 20 weeks that you can actually think of it in that sense. Beyond 20 weeks to 24 weeks is that time period where it is the explanation that covers, and there are these special circumstances that we've spoken about.
Yeah.
And also, if you feel that you are under one of those special circumstances, you can obviously approach the Supreme Court under Article 32. However, it is then upon the judges to decide whether or not that special circumstance is there. Because what happens is that when a termination takes place, there are two ways. One could be that the fetal's heartbeat would be completely stopped. There are also chances of survival, and then that child becomes the burden of the state to take care of.
Right.
That child at 24 weeks would have mental disability, physical deformities. So then, then it is basically you're evaluating a mother's right vis-a-vis a child's right.
Right.
So I think that's where the fetus viability debate is also coming in so much, that what if, and then we are looking at the different scenarios that are there.
So till 20 weeks, we have medical practitioners who take care of whether or not a woman's pregnancy can be terminated. Could you tell us a bit about the factors that they usually consider, and can the medical practitioner's decision be challenged in courts?
It can be challenged. Any decision, as we've seen, can be challenged in court, but that is also subject to if the court finds it something which is necessary for them to entertain also. Otherwise, we will see that a lot of times people will keep changing their mind and then taking it forward. So maybe at 12 weeks I decide, okay, I want to continue, and suddenly at 20th week I decide. And these are not the circumstances that we've just discussed.
Right, yeah.
So then in that case, we can't be using the court or the judicial system to, have it our way. So therefore, the judgments that come, they always come in peculiar facts and circumstances of the case.
Right.
And every single case, they actually go through it. Even in the case that we are discussing in hand, she approached at 24th week, and I think 24th week is when she approaches, 24th week in some days. 25th week and 5 days is when you have the two judges bench judgment that comes in, and then at the when she's about to enter the 26th week, then we have the 3 judges bench judgment that comes in. So, it is not that the judiciary is not taking it seriously, but also they want to make sure that this doesn't open up the Pandora's box of, frivolous petitions then coming in.
So coming back to the debate, Pallavi, when this matter was being heard in the Supreme Court, so the Chief Justice of India, Justice D.Y. Chandrachud, very specifically commented, which you also said as we initiated this discussion, that the law dealing with abortion is very progressive in India, because it has actually balanced pretty well the rights between a woman and the rights between an unborn child. So how do you see this remark, and what do you have to say?
I think if you look at it, we are absolutely extremely progressive. I mean, I remember, I'm sure, Bhadra, you also wrote up something about Roe versus Wade, or I'm sorry.
No, Apoorva wrote.
Apoorva wrote, yes.
Yeah.
But those articles itself referred to all the things which are wrong in the Western world, and we are all looking at Western countries and looking at how progressive they are. However, if you look at India, 1971 itself, we had a medical termination of pregnancy, which was there, and this was seen through. Even though we are looking at definition now expanding, I'm sure we will see fetus viability also coming into play. And interestingly, there are certain words which are avoided in the judgment, because we are not really looking at pro-life, pro-choice and these terminologies which ignite so much debate here.
Right.
But the way the judgment is written, and the way Justice Chandrachud has very beautifully drawn the distinction in how India is and how we are actually operating within our own statute, is just beautiful. In the way that he says that, we are progressive, we have these rights which have come up for everybody, but we are also looking at the rights of that which is unborn, that doesn't have right now a voice to say. And I think that part is very beautifully written, and he's very interestingly gone through every single statute, and he's even gone through the brief history of it, and he's talked about how it has evolved. And he's also talked about what are the powers that a judge has as far as 142 is concerned, and whether all of these conditions would actually come under 142 or not. I think that part is interesting also, because when we look at this medical termination of pregnancy of a woman who says that I am under these circumstances, and Section 3 also says that it is not just the physical, that if a pregnancy brings about physical harm to a woman, it also says physical and mental harm to a woman.
Both.
And this is where she says that, okay, I am actually undergoing through a mental trauma because of postpartum depression, and now with this unplanned pregnancy. Therefore, I should be given. So when she comes under Article 32, these are her prayers. These are her grounds because of which she prays that I should be allowed to terminate. I think that part he is very beautifully dealt with. He says that I understand that you are going through troubled times, and these are problems that you're facing. However, there is also fetus who's viable and who will unfortunately end up being physically or mentally challenged. So now I have to make sure that I do justice. And how do I do justice? I give you an opportunity to have the child. The state is going to bear the expenses. And then tomorrow, if you decide you don't want to have a baby, or you don't want to keep the baby rather, you can put it up for adoption and we'll take care of it. So I think this is a very, very progressive and a very positive way of finding a solution to it. So I think Justice Chandrachud, as always, lives up to his expectation of a good judgment. Yes.
Pallavi, one question, maybe the last question which I would like to ask you is that the MTP Act, of course, it's a government legislation. So, and many a times it has come under criticism to the extent that, people say that the government is interfering in the rights of a woman by having this kind of a law. In fact, in this particular case also, we saw that the government had actually fought back the woman's demand. How do you see this entire thing?
I think, like we always say, all good things also come with the bad things in it. So, whenever we have the good parts where we see that there is some kind of progressive legislation which has come, there are always drawbacks, because at some stage or the other, certain parts will be left unsaid or certain parts will be prohibited completely. And we've seen that with every single legislation that has involved women. However, that's where the judiciary comes in and tries to, make all the wrongs right. But I think it's still now with this debate about fetal viability, I think this will again ignite and we'll see another 4-5 years some kind of an amendment happening in this. But having said that, when it comes to a woman and her right to have a child or not to have a child, I am not sure if the weeks part that we are talking about, if it is 26 weeks or if it is 24 weeks, if a fetus has a heartbeat at 7 weeks also, then you're terminating it at that stage
That's
as
right.
well.
Yeah.
So I think one needs to know exactly where that line is to be drawn about a woman's right and also about a child's right, I think. Yeah.
Right. On that note, we've reached the end of this episode. In this episode, we spoke about abortion laws and we spoke about the debate that has been reignited. However, as Pallavi said, the judgment that has seems to have reignited that debate also, in her opinion, is quite progressive. I will be adding a link to that judgment as well as all the articles that Bhadra and I have done on the abortion laws in India, on Roe versus Wade, as well as this Supreme Court's judgment. So if you're interested in it, please do take a look. Thank you so much for watching.